Today we're going to focus on the Supreme Court. While we're looking at the most important court in the judicial branch, please think of these questions. What is the Supreme Court's jurisdiction? Examine how cases reach the Supreme Court, and how does the Supreme Court operate? Our quote today is from Franklin Delano Roosevelt, one of the most important presidents in American history, and he said, "We want a Supreme Court which will do justice under the Constitution, not over it. In our courts, we want a government of laws and not of men." Now, do you agree or disagree with FDR? I also want to mention this quote comes from the man who tried to pack the court or make more justices so that they would agree with him during the Great Depression. As you can see from this political cartoon, he did not get his way. The Supreme Court of the United States is the only court specifically created by the Constitution in Article 3, Section 1. The court is made up of the Chief Justice of the United States, whose office is also established by the Constitution, and 8 associate justices. In order to be a Supreme Court justice, 3 things need to happen. You have to be nominated by the President, your nomination needs to be approved by the Senate, and finally, the President must formally appoint you to the court. The Constitution doesn't specify any formal requirements for their justices. That means that there's no age requirement, education requirement, profession requirement, or citizenship requirement. The framers quite purposely placed the court on an equal plane with the President and Congress. As the highest court in the land, it stands as the court of last resort in all questions of federal law. That is, the Supreme Court of the United States is the final authority in any case involving any question arising under the Constitution. The Supreme Court has both original and appellate jurisdiction. Most of its cases, however, come on appeal from the lower federal courts and from the highest state courts. The Supreme Court hears only a very small number of cases in its original jurisdiction. In fact, probably no more than a case or 2 each term. Another important thing we need to know about the Supreme Court is how cases reach the Supreme Court. As you can see from this diagram, it looks fairly simple. However, it's a complex process to actually get your case to the Supreme Court. While I was looking into this, I found an awesome video from Vox, and I think it explains the process very well.
Old TV shows made it seem really easy to appeal to the Supreme Court, like when this lady wanted to fight her speeding ticket.
I am going to win this case. If not here, I'll appeal to a higher court. If necessary, I'll take it to the Supreme Court.
Or on Gilligan's Island, when Thurston Howell is locked in a bamboo jail and he says,
"I'll take it to Supreme Court."
But even though they make it sound like a right, nobody is entitled to an appearance at the Supreme Court. That's entirely at the discretion of the justices. And they choose very carefully. Only a small number of cases get to the Supreme Court, and it's getting smaller. Roughly 8,000 cases are submitted each year, but only 80 cases are accepted. That's a 1% acceptance rate. And to get to that 1%, most cases start at the bottom. The federal court system consists of 3 layers, and the lowest is the district level. If you lose in a district court, you can appeal to the circuit level. Most of the United States is divided into 11 circuits, but there's a 12th for DC and a federal circuit that mostly hears patent and military cases. Above the circuit level is the Supreme Court, the highest court in the land, as long as you don't count the basketball court that's above the Supreme Court. And to get to the Supreme Court, nearly all cases require submitting something called a petition for a writ of certiorari.
The writ of certiorari, which is shortened usually to writ of cert.
A petition for the writ of cert is a written request asking the Supreme Court to hear a case, instead of asking the court to resolve the facts of a case, which are nearly always settled in lower courts. The reasons for granting the petition concern important questions about federal law.
The overarching goal of the court is to make sure that federal law is the same across the country. And so by federal law, I mean the U.S. Constitution and laws passed by Congress.
Professor Green clerked for Justice John Paul Stevens, where he became very familiar with cert petitions. That's because the clerks review cert petitions for their justices, who then choose to grant a petition if it passes the rule of 4, meaning that 4 justices want to hear the case. When the court does not grant cert, it does not imply a decision.
It doesn't mean that it agrees with the lower court. It doesn't mean that the individual justices agree with the lower court decision. It just means that the court has decided that this particular case is not a case where the court is going to choose to set the law for the whole country.
If cert is granted, a case probably falls into one of three categories describing most Supreme Court cases. The first is a case of national importance, such as when the court decided Bush v. Gore in order to help determine who had won the 2000 presidential election.
Drawing on very rarely used legal powers, the Supreme Court has, for the first time in American history, decided to step into a legal dispute in the midst of a presidential election.
A second type of case is when a lower court issues a ruling that invalidates federal law. An example is Gonzalez v. Raich, in which Angel Raich, a California woman, challenged federal drug laws after agents destroyed marijuana plants she had been consuming for medical use. On her appeal in the Ninth Circuit, judges ruled in favor of Raich, deciding that she was compliant with the state law authorizing her use of medical pot. But that ruling conflicted with federal law prohibiting marijuana use.
So when the Ninth Circuit said it doesn't apply, that means if you're a medical marijuana user in California, then you can use it without fear of federal prosecution. But if you are a medical marijuana user in Florida or in New York, then it's still banned under federal law.
By ruling on the case, justices were able to establish the authority of federal law prohibiting the use of medical marijuana.
In the Raich case, the Supreme Court overruled the Ninth Circuit and said that the federal drug laws can apply to local marijuana use, which means that someone like Angel Raich can still be prosecuted under federal law, even though she can't be prosecuted under state law.
Third, the court accepts cases in order to resolve a split decision in the lower courts. This happened in the case of Obergefell v. Hodges, where a Sixth Circuit ruling that banned same-sex marriage conflicted with rulings in other circuits that had upheld the right to same-sex marriage.
The Obergefell was someone living in Ohio who wanted to marry his same-sex partner and was not permitted to do so under Ohio law. It made its way to the Sixth Circuit. The Sixth Circuit said you have no right to be married because you're a same-sex couple. And that created a split, a division of authority between the Sixth Circuit, which governs Ohio, and a number of other circuit courts. And so once that happened, it was fairly clear to, I think, most legal observers that the Supreme Court was likely to hear the case because it meant that the federal law, the federal constitution in this case, applied differently in Ohio than it would in Pennsylvania, for example.
By ruling in favor of Obergefell, the court resolved a circuit split and made same-sex marriage a right nationwide. But these three categories are just a framework for understanding why the court might select a case. They are not rules. Ultimately, which cases get to the court depends on the decisions of individuals, the sitting justices of the U.S. Supreme Court.
The Supreme Court sits from the first Monday in October to sometime the following June or July. Each term is identified by the year in which it began. Once the Supreme Court accepts a case, it sets a date on which that matter will be heard. As a rule, the justices consider cases in 2-week cycles from October to early May. They hear oral arguments in several cases for 2 weeks, then recess for 2 weeks to consider those cases and handle other court business. On those days on which the court hears argument, it convenes at 10 a.m. on Mondays, Tuesdays, Wednesdays, and sometimes Thursdays. At those public sessions, the lawyers representing the parties of those cases the court has accepted makes their oral arguments. Their presentations are almost always limited to 30 minutes. The justices usually listen to attorneys' arguments and sometimes interrupts them with pointed questions. After 25 minutes, a white light flashes at the lectern for which an attorney addresses the court. 5 minutes later, a red light signals the end of the presentation and it must stop, even if the lawyer is in mid-sentence. Each party files detailed written statements, also known as briefs, with the court before they present their oral arguments. These detailed statements spell out the party's legal position and are built largely on relevant facts and the citation of precedents. Briefs often run to hundreds of pages. Court may also receive amicus curiae, or a friend of the court briefs. These are briefs filed by a person or a group who are not actual parties to a case, but who nonetheless have a substantial interest in its outcome. Another important person you may see in the Supreme Court is the Solicitor General. He's the principal officer in the Department of Justice, and he's also known as the federal government's chief trial lawyer. He, and certainly one day she, represents the United States in all cases to which it is a party in the Supreme Court, and may appear and argue for the government in any federal or state court. On most Fridays through a term, the justices meet in conference. There, in closest secrecy, they consider the cases in which they have heard oral arguments, and there, too, they decide which new cases they will accept for decision. Only the Chief Justice who presides and the 8 other members of the court are present at the conference. The Chief Justice leads the discussion of each case to be considered. He states the facts, summarizes the question of law involved, and usually indicates how he thinks the court should dispose of that case. Then, each of the associate justices, in order of seniority, present their views and conclusions. A majority must decide which party wins or loses a case, and whether a lower court's decision in that matter is to be affirmed or reversed. About a third of the court's decisions are unanimous, but most find the court divided. The High Court is sometimes criticized for its split decisions. However, most of the cases it hears pose difficult and complicated questions, so we can really give them a break. In short, most of the court's cases excite controversy. The easy cases seldom get that far. Once a case has been considered and decided in conference, the court announces its decision in the matter, and with it, issues one or more written opinions. The decision indicates which party has won and by what margin among the justices. Where the decision is unanimous, the Chief Justice most often writes the court's opinion. If there has been a split decision, the Chief Justice may write the majority opinion, or he may assign the task to another justice in the majority. When the Chief Justice is in the minority, the senior justice in the majority makes that assignment. So let's look at different court opinions. The majority opinion, officially called the opinion of the court, sets out the facts in a case, identifies the issue it presents, and details the reason that underpin the majority's decision. One or more of the justices on the majority side may write a concurring opinion, usually to make some point not made or not emphasized in the majority opinion. Now, one or more dissenting opinions may be written by those justices who do not agree with the court's majority decision. Those dissents do not become precedent. They are instead expressions of opposition to the majority's view in the case. Now that we've looked at the Supreme Court, I have a few things for you to answer. First and foremost, do you think there should be more than 9 justices on the Supreme Court? Furthermore, do you think each president should be able to nominate at least 1 justice per term? Do you think the method for selecting Supreme Court cases are fair? And lastly, do you agree or disagree with Franklin Delano Roosevelt's quote, "We want a Supreme Court which will do justice under the Constitution, not over it. In our courts, we want a government of laws and not of men." Why? I look forward to hearing your answers.